Hello, good morning, Attorney Jake. I am Maria Cecilia Pigulay with Mr. Jory Casperi, and today we'll be discussing about extinguishment of obligations under Article 1231 to Article 1251, Section 1, which is payment or performance. So, Article 1231 talks about how obligations are extinguished by payment or performance, by the loss of thing due, by the condonation or remission of the debt, by the confusion or merger of the rights of creditor and debtor, by compensation, and by novation. But today we'll be just talking about the payment or performance. Article 1232 says that payment means not only the delivery of money, but also the performance in any other manner of an obligation. So it means that when you already have an obligation, then you have to pay it in order to extinguish the obligation. But the payment is not only limited for payment by money, but also the performance, which is the doing or not doing of something. And there are two types of requisites of payment, which is the identity of the prestation and the integrity. Identity of the prestation means that the prestation must be delivered or performed based on what contract you've agreed upon. While integrity, it means that the prestation must be fulfilled completely, not partial or irregular. In 1234, if the obligation has been substantially performed in good faith, the obligor may recover as thought there had been a strict and complete fulfillment, less damages suffered by the obligee. Now, Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover as thought there had been a strict and complete fulfillment, less damages suffered by the obligee. So, Article 1233, a debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered as the case may be. So, Article 1233 decides of when the debt must be considered paid. So, the debt is considered paid when the thing or service that the creditor and debtor agreed upon is delivered completely. So, Article 1234 says that the payment must be completed to extinguish the obligation, and it must be substantially performed and within good faith. Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. General Rule, Principle of Integrity. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists have been completely delivered or rendered, as the case may be. So this article still means that the payment must still be completed to extinguish obligation. But if despite knowing that the performance is incomplete or irregular, but creditor still accepts that payment without objection or rejection, then the obligation is fully complied or extinguished. So, Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid without the knowledge or against the will of the debtor. He can recover only insofar as the payment has been beneficial to the debtor. So, the first paragraph provides a rule of which payment must creditor bound to accept, which is the debtor. If a third person who has no interest or part in an obligation but decides to pay, then the creditor cannot accept it unless there is a stipulation that he can make payment. Now, for the second paragraph, it talks about what is the effect of the payment of a third person that has no interest but just wants to pay for it. It says that the debtor's knowledge and consent may demand after the debtor of what he has paid either reimbursement or subrogation, which is that he is now entitled to rights and actions that a creditor can do. Now, if the payment of a third person is without the debtor's consent or knowledge, then he can recover only insofar as the payment has been beneficial to the debtor. So it means that he has only the beneficial reimbursement but not the subrogation, which is that he can recover only payment to that extent that the debtor was benefited. Next is Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. So this is the one I discussed from earlier, and it is expressly provided under Article 1237. So as I said, if the third person without the knowledge or against the will of the debtor, then he cannot compel the creditor to subrogate him in his rights. But he can just only recover the payment that the debtor was benefited to the extent. So next is Article 1238. Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent, but the payment is in any case valid as to the creditor who has accepted it. So this means that the third person who is paying the obligation of debtor is deemed to be a donation with no reimbursement to be made. But in order to be a donation, the donate or debtor must accept the donation first of the donor, and if the creditor accepts the payment, then it is valid to him as the payer, although the debtor doesn't give his consent of donation. Next is Article 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due an incapacity to alienate, it shall not be valid, without prejudice to the provisions of Article 1427 under the title on natural obligations. General Rule: payment by an incapacitated person is not valid. So these provisions talk about the effect of payment by incapacitated person. So it means that the payment of incapacitated person is not valid, and so the creditor cannot compel to accept it. Next is Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or a successor in interest, or any person authorized to receive it. So this discusses to whom payment must be made. Person in whose favor the obligation has been constituted, creditor or obligee. His successor in interest, or any person authorized to receive it. So this provision talks about to whom payment must be made. Article 1240 said that in whose favor the obligation has been constituted, which is the obligee or creditor, or to the new person who has been subrogated to the rights of the original creditor, his successor, or to the person authorized of the creditor. So now Article 1241 to Article 1251 will be discussed by Mr. Joric Espere.
Article 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to creditor need not proved in the following cases. Number 1. If after the payment, the third person acquires the creditor's right. Number 2. If the creditor ratifies the payment to the third person. Number 3. If by the creditor's conduct, the debtors has been led to believe that the third person had authority to receive the payment. These provisions talks about the payment to incapacitated or unauthorized person. The first paragraph is the payment to a person who is incapacitated, but it shall be valid if he has kept the thing delivered or the payment has been beneficial to him. To the second paragraph, it talks about payment made to a third person shall also be valid if it has rounded to the benefit of creditor, but there are following cases that the benefit to creditors used is not proved. The cases number 1 and 2 and 3. Article 1242. Payment made in good faith to any person in possession of the credit shall release the debtor. So this is another situations. The payment must be in good faith and the possession of credit itself, meaning it is the possession of the credit. It is not necessarily evidencing the credit. Article 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. So this provision discusses about payment after judicial order to retain the debt. So let's go to Article 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as, or more valuable that which is due. An obligation to do or not to do an act for forbearance cannot be substituted by another act forbearance against obliges will. The first paragraph refers to our real obligations to deliver a specific thing. The second paragraph refers to the personal obligations to do or not to do. So the provision explains that the debtor cannot compel the creditor to accept different object. Exceptions: the facultative obligation, agreement resulting in addition in payment, waiver by the creditor if he accepts the substituted object. Next is the Article 1245, dation in payment, whereby property is alienated to the creditor is satisfaction of a debt in money, shall be governed by the law of sales. Dation in payment. It is a special form of payment. It is a mode of extinguishment whereby the debtor gives a property in order to satisfy the monetary debt. This article says that it shall be governed by the law of sales. In sale, there is no pre-existing credit, while in dation and payment, there is pre-existing credit. And the obligations in sales are created, and in dation and payments are extinguished. Go to the Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing whose, whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor can the debtor deliver a thing of inferior quality. The purpose of the obligations and other circumstances shall be taken into consideration. So, these provisions is also called the rule of medium quality. Unlike to the obligation to give a specific thing, the rule is the creditor cannot demand a thing of superior quality, so he can accept an inferior quality, while the debtor cannot deliver an inferior quality, but he can deliver a superior quality if he wanted, because in these provisions says that whose quality and circumstances have not been stated. Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. These provisions state that the debtor have the obligation to pay for extrajudicial expenses for the payment. If they don't have an agreement, if who will pay the extrajudicial expenses, the debtor will have the obligation to pay because it is provided by the Article 1247. And let's go to Article 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidations of the latter. So, according to the general rule, payment must be complete. These provisions provide another exceptions. The partial payments is allowed first when there is stipulations to that effect. Next, exceptions is when debt is in part liquidated and in part unliquidated. Article 1249. The payments of debt in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. The delivery of promissory notes payable to or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in the abeyance. So, the first paragraph states that this provision repealed by the Republic Act 529 states that prohibited the stipulations of the currency than Philippine currency means that other currency is not allowed that time. But later on, Republic Act 8183, which is repealed the RA 529, means that as of now, obligations or transactions may now be paid using the agreed currency, not necessarily Philippine currency. The second paragraph states that all mercantile documents and like check, they are not like legal tender. The creditors cannot be compelled payments through this. Like if you pay using promissory notes or like checks, creditors cannot be compelled because it is not a legal tender. Article 1250. In case an extraordinary inflation or deflation of the currency stipulated showed supervene, the value of currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. This provision states that this is only applicable to the case where contracts or agreement is involved. The inflations in the Philippines is only ordinary. If it becomes extraordinary, the basis of the payment is the value of the currency at the obligations is constituted. Article 1251. Payment shall be made in the place designated in the obligation, there being no express stipulations, and if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. In any other cases, the place of payment shall be domicile of the debtor. If the debtor changes his domicile in bad faith or after he has incurred in delay, and the additional expenses shall be borne by him. These provisions are without prejudice to renew under the rules of court. So, this provisions talks about the place where the obligation shall be paid. If there is no stipulation, we must classify if the deliverer is a specific or determinate thing. If the undertaking is to deliver a determinate thing, then the payment shall be made the thing might be at the moment the obligation was constituted. Application of payments. Application of payments is the designation of the debt to which should be applied the payment made by a debtor who has various debts of the same kind in favor of one and the same creditor. Dation in payment. Dation in payment has been usually defined as the transfer of the property of an asset in settlement of outstanding debts. In other words, the debtors transfers as an asset to the creditor, and the creditor accepts it as payment in settlement of an obligation. Next is the payment-based cession. Payment-based cession is another special form of payment. It is the assignment or abandonment of all the properties of the debtor for the benefit of his creditors, in order that the latter may sell the same and apply the proceeds thereof to the satisfaction of their credits. Tender of payment and consignation. If the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by consignation of the thing or sum due.